The California Consumer Privacy Act is a law designed to protect users, to allow users to get back from social media companies their content, among other things. When a business has been issued a California Consumer Privacy Act data request, the business must comply with that request. It's not an optional request. The business is required by law to provide and furnish to the user up to 2 requests in a 12-month period for that user's data. All of the posts, all of the content related to that user must be turned over to that user. This is a consumer protection law that allows users to, for whatever reason, get back the content that they published, such as in the event where they have published content that they want to now port to another platform. And this could very easily happen if the user has been suspended or banned or had action taken upon their account on the platform that they're publishing content, and they're having a problem with that particular platform. They want to get their content back and put it somewhere else. They have the legal right to do that under the law now, thanks to this law. However, the law is actually totally useless. And the reason that I say that is that it is unenforced. The law is supposed to be enforced by the Office of the Attorney General, and that doesn't happen. The District Attorney doesn't enforce the law. The Office of the Attorney General does not enforce the law. What they do is they provide a quick image of how the user can uphold their rights. And the user is supposed to just look at that graphic and say, oh, I can just go to the company's website, and there's usually a link somewhere on the website you can just click. Right. But that's not what the law says. The law says that the company must furnish an email address to submit requests to. Right. The Office of the Attorney General then further goes on to say that you can submit a complaint to the OAG by using our form, which is a form of one-way communication. I submit the form as the user to the OAG to file a complaint about a company, and the OAG provides no acknowledgement of having received that form, no receipt of what I have sent. They don't give me a copy of the message back stating the date and the text in the message that I sent to the OAG. So I don't have any record of having sent that. It's all done through a web form. This is the exact problem that is designed to be avoided by the text of the law when they state that the company must provide an email address to submit requests to. So that way I have a record. I can send the company an email, request my data, and if they don't comply, I have a record of that they failed to comply. Whereas when the company publishes a button on their website and says I need to log in and then go click the button on a certain weird page in some nested place, and it doesn't work for whatever reason having to do with their JavaScript or their design or the fact that they suspended the user account, that I have recourse, right? Because I didn't go through that process. I sent them an email from my email account using my email software. I have a record of that. I have control over what I've communicated to them, and I haven't been forced to communicate through their broken communication channel, which restricts users and in many cases doesn't allow users who have been suspended to file CCPA data portability requests. Right? So that's the design of the law, and the OAG implements the exact opposite of that by requiring users to go through the OAG's website. Now, the district attorney is supposed to uphold the law also. And so I have contacted the district attorney on 3 occasions. On each occasion, the representative hung up on me. The first time I was transferred. The second time I was basically told off. And each time I was hung up on. So I waited on hold for a long time, got transferred around, got told off, and hung up on 3 times. They don't enforce the law, at least not consistently. If they do enforce the California Consumer Privacy Act at all, if they ever do uphold the law, then it is only selectively done and not consistently done. Any law that is selectively enforced provides inequality under the law. It prevents equality under the law. Saying that some users get some rights and some people don't have those rights is by definition inequality. That's a problem. I think we need an Office of Internet Rights. I think we need an office where users can go to and fill out a form and say, I have the right to get back my data, to get back all of my contacts, to get back all of the information that I have input into that application. I can get that back, and here's how I'm going to do it. And I'm issued my request. And if they've refused to allow me to issue the request, that's a problem. If they've allowed me to issue the request and refused to comply with it, either by ignoring it, by pretending that they never received it, or by outright refusing to comply with the request, then that's a problem. Okay? And the fines for companies failing to comply with the law should be sufficient to motivate them to comply with the law. It should be easy for users to file a complaint, and it should be a severe enough punishment for the company violating the law so that they cannot do it on a large scale and play dumb and pretend that they don't know what's going on, which is exactly the problem that we have now, right? Because now if I want to file a CCPA request to Twitter, a California company, Twitter, a large company worth over $25 million, with much more than that, actually, I can't do it. Why not? Why can't I file a CCPA request? Because Twitter provides instructions on their website for how to do that. And the instructions say, in the top menu, tap your profile icon. Okay, but I'm suspended. Then tap settings and privacy. I'm suspended. Tap account. Under data and permissions, tap your Twitter data. I'm suspended. I can't do any of that. So when I go to twitter.com, what I see is nothing that will allow me to do any of that. Right. I don't see that. I see a warning page that says my account has been temporarily suspended and that somebody is going to come and review that right away. This has been going on for a year. Temporarily suspended. We're going to look into that right away. But yeah, it's been a year. Yeah. So whatever I was suspended on shouldn't matter. In accordance with the law, it absolutely doesn't matter. No matter how many people's feelings were hurt by the things that I put on Twitter, doesn't matter under the law. Right? It could have been everybody's feelings could have been hurt. Now, if I had posted something horrible, right, some really ugly racist shit on Twitter, would that make Twitter look bad or would that make me look bad? Right? Most people nowadays, if they saw something like that, you know, I might influence a few people who say, yeah, I agree with you. But by and large, it's not going to win me much popularity. Right? You're not going to get anywhere with that, right? Because that's just not something people want to see. People don't agree with that, you know. So fine. So Twitter wants to be offended by that, or Twitter wants to prevent things that aren't what I'm not saying that what I posted was hateful or ugly or disgusting, but if Twitter finds them to be so, and they want to delete those things and prevent those things from being seen by others, then they have the right to do that. They also have the obligation legally to provide to me and furnish to me a way to get that data. I have a right to get that data back, and they have to allow me to do that via an email address. Twitter saying that I need to log into the website violates the law. Now, the law clearly states does two things. It says that they must inform the users before collection. It says a business that operates exclusively online and has a direct relationship, I'm quoting from 1798.130 from California Consumer Privacy Act. Business that operates exclusively online and has a direct relationship with a consumer from whom it collects personal information shall only be required to provide an email address for submitting requests for information required to be disclosed pursuant to section 1798, 110, and 115. Right. That says that they don't have to provide a toll-free number, which it mentions earlier, but they do have to provide an email address. Twitter doesn't do that. Twitter doesn't comply with the law. They violate the law. Nextdoor does the same. Reddit does the same. So what does the Office of the Attorney General do? Almost a year and a half after they've been promising to start upholding the law, they don't uphold the law. At least if they do, they're doing it selectively because they have refused to acknowledge my CCPA data portability request, which I had to submit through the OAG's website form. I called 3 times. I got hung up on, and was rudely hung up on and had to wait for a long time, got nowhere. Right. So the message to the consumer, which in this case I'm one of them, is forget about upholding your rights. We don't care. This is just a placeholder law to make it look like you have rights as a consumer. It does nothing. We're not going to enforce the law. We're not going to uphold this new law that we just created and enacted. It's not just like we're having trouble rolling it out. It's over a year old. It's been on the books for over a year, and they don't do anything. Now, what they promise to do is for each violation, they say that they can fine the company up to $2,500. But it has to be a company that has a gross income of over $25 million. Right? $2,500 fine per violation only for companies that make over $25 million. Right? That's like 1/10,000th of the company's gross income. Right? That's nothing. And so for companies that know this, they don't care. Do you think Facebook cares? That's not 1/10,000th of Facebook's annual income, which, by the way, is much more than $25 million. Facebook doesn't care. Facebook getting fined $2,500 is not a big deal for Facebook, unless it happens on a broad scale. Now, the only way that it could happen on a broad scale, if consumers were able to file these data portability requests easily, and there was accountability for it. If there was an Office for Internet Rights where consumers could say, I filed a complaint on this date, here's the copy of it, here's my driver's license, here's the proof that I filed it, and here's my name on the email, I sent it off, and they've got their email, and they've got all the records of that, and they file it with them, and somebody takes a look and says, oh, you filed a complaint, where's the response from the company? The company has no response. They contact the company's office for CCPA data portability requests. They say, hey, we've got a request here from a guy, a gal, and they said they filed a request, and this was 2 months ago, you have to comply with this. And if the company comes back, the company could say they've already filed 2 in this 12-month period, so we don't have to comply, which is part of the law. Or the company could come back and they could say, they could try to find some other reason. They could say, we didn't comply because we didn't receive it. Or we were not able to understand the request because it was the email was properly formatted. They didn't provide their user account. They didn't say who they were. We got just some random email address and we couldn't process that. We need the user to fill out this information before we can process it. Right? So then there's a due process of getting back your data, right? You have accountability and there's some office that's going to uphold consumer rights. So, consistently, right? It's not rights for certain groups, not rights for certain privileged classes of people, right? No, it's rights and freedom for everybody, regardless of anything. And the office will uphold those rights, say, okay, you filed a complaint. Let's look at the facts of the matter. We'll go to the company, and we'll see what's going on with that. And if the company didn't comply with the request, if the company had a mistake, they did something wrong, whether deliberate or unintentional, then the company can be fined. They can be fined even up to $7,500 for intentional violations. Now, companies know this, but they don't care. Facebook, in case of me, decided that, well, they took a look at my case when I filed CCPA data portability requests. Let's take a look at that. In August of 2020, I filed several of the CCPA data portability requests on Facebook. Facebook makes it very difficult to do this. They have a special form you have to find. It's hard to find it. So I filed that. It was denied, summarily denied. First, I got email responses telling me that I could download the data if I just go into my account and find the place where it exists and do a search through Facebook, for Facebook search. But no, it's not there. It's not there. Why is it not there? Well, Facebook deleted it. So I started issuing CCPA data portability requests all over the place to different email addresses to Facebook and also to Mark Zuckerberg's feed. Every time Mark Zuckerberg would post something on his feed, I would put the CCPA data portability request formal legal letter as a comment. And that just seemed to get me some negative attention from some other people at Facebook who eventually suspended my account for something unrelated. But Facebook eventually acknowledged that a valid CCPA data portability request had been submitted to Facebook. They acknowledged that it had several months later, late October, and they refused to comply with the request. They outright said they're not going to follow the law. They just said, we're not going to follow the law. And the excuse that they gave was essentially that what I had posted violated their terms of use. Right. They said anytime somebody has a serious violation of our terms of use, They didn't say community guidelines here. Anytime someone has there's a serious violation of our terms of use, we reserve the right to not furnish the user with their data. But nowhere in the law does it say that the company can willy-nilly, arbitrarily pick and choose which CCPA data portability requests. I don't care about the phase of the moon, or if you think that the person's icky, or you want to call it racist, or somebody was offended. That doesn't matter under the law. The only thing that matters under the law is what the law says, and the law doesn't say any of those extra special things that Facebook is making up as excuses for violating the law. Right. Facebook actually said that to them in the email that they sent to me. The law clearly states, and I have the email dated October 2020, but the law in 1798.100 clearly states, verbatim, a business that receives a verifiable consumer request from a consumer to access personal information shall promptly take steps to disclose and deliver free of charge to the consumer the personal information required by this section. The information may be delivered by mail or electronically, and if provided electronically, the information shall be in a portable and, to the extent technically feasible, readily usable format that allows the consumer to transmit this information to another entity without hindrance. A business may provide personal information to a consumer at any time, but shall not be required to provide personal information to a consumer more than twice in a 12-month period, which is a poor limitation of the law if they're only required to provide 2 per 12-month period. That's, I think, not a strong consumer rights law. It should be at least 12. They can provide up to 1 a month, right? If they deleted your content 1 month and then they decide they're going to delete your content the next month and you can't get it because you've already gotten 2 in a 12-month period, that's not reasonable. It doesn't protect consumers very much, and it's a very low cost for the company to furnish their data. Say, okay, here's your data. Let's select this data. If we can't select data from our database, we need to fix our data problem because we're not managing our data properly, right? And none of these companies, these big technology companies, are having problems managing their data or our data. In fact, they're doing quite well by selling and managing our data to predict and control and influence what people think, to silence certain voices, amplify other voices, control search results, and modify social and public opinion to create the illusion and the perception of what they want society to be. They want society to believe a certain way, and they want society to be a certain way. So both believe and to be. I think we need an Office of Internet Rights. I think this situation is untenable. The Office of the Attorney General is not helpful. They are at best useless, and at worst, if they are enforcing any CCPA data portability requests, then they are so doing selectively, and that's unequal treatment under the law. It's not helpful, it's not feasible, and what we need to do is create an Office of Internet Rights for consumers to file these requests so that consumer rights can be upheld. The fines for violations need to be higher. $2,500 is too low, unless it's very easy to file complaints and companies are receiving complaints and violations on large scale, en masse. If you're receiving a $2,500 fine times 10, that's $25,000, times 100 is $250,000, times 1,000. Now we're starting to talk a serious amount of money, right? That's what we need. We need to be able to punish these companies for violating our rights, not waste hundreds of hours of people's time to try to chase down and assert their rights, and killing poor people who don't have the means to hire and pay an attorney on retainer $10,000 or $12,000 or $15,000 to uphold their rights. Thank you for watching.